immature behavior on his part, but it didn't rise to the level of a family offense. I don't believe that there was sufficient evidence to infer that he intended to seriously annoy or alarm her, and there was a legitimate purpose in him being there. He went to pick up his children. He was there picking up his daughters.
So I understand there was a legitimate purpose to him being in the vicinity. Okay?
Yes.
There's nothing wrong with these children. They could walk from the house to his car, and I'm just struggling with any legitimate reason for him to park in the mother and do the things that he's done, except to harass her. Okay? I mean, I'm really having a hard time buying your argument, counsel.
Okay, well, I do think, first of all, I think that it's very telling that the police never arrested him for this. And it was uncontested that the police were called multiple times by the neighbor as well, and they never arrested him. They showed up once, I think, but so the police obviously thought that he was there for a legitimate purpose, and the order of protection.
That we should accept that jump in faith there, that because the police didn't arrest him, that they accepted his explanation?
Well, I think that they didn't arrest him for a violation of the order of protection, and they didn't arrest him for any kind of a crime. I mean, they would have arrested him if they thought he was committing a crime, if they thought he was really harassing her.
Maybe counsel, that's because they had arrested him 3 or 4 other times.
Well, that was before. That was before. That had nothing to do with the parking.
But there's a history here, isn't there?
Yes.
Yeah.
That had to do with the children too, though. He was both times he was picking up. He was visiting his children.
Maybe part of the testimony that he says, I didn't stick my tongue out at her when I went to the door, but there's a photograph of him doing that.
Well, I believe the photo doesn't show him sticking his tongue out and saying anything. It does show him at the door. Right. Yes, but I believe he said that he was picking up his children at that point, so that was why he was there. But yes.
So just so I understand it, your argument here is there's no dispute about where he was parking, what he was doing. It was just immature, but not
exactly.
harassment.
Okay,
Exactly.
I think we have that argument.
Okay, thank you.
Thank you. 683, Jacqueline Burkett versus Aaron O'Toole. Okay, you're solo. Go ahead. But unmute yourself first, please.
Thank you, members of the court. James Alexander for plaintiff appellant in this matter, Jacqueline Burkett. I'd like to state a very brief facts that are pertinent to this, and then review the several errors.
We know all the facts, so you can go right to your argument.
All right. So there was objective findings, including the MRI showing herniated disc desiccation, and also facet arthropathy. So the objective findings were there. The qualitative findings were there.
Okay, now let me stop you right there, and that's where I think we're having some, hard time grabbing onto what the qualitative findings were. If you could tell us what they were and where they appeared in the record, we'd like to know that.
Okay. The qualitative findings were stated in the plaintiff's deposition transcript about the various problems and difficulties that she has, which include consistent chronic pain ever since the accident, inability to stand or walk for any period of time, problems sleeping, restricted activities of not being able to hike or bike, reduced ability to perform household chores. And all of this is consistent with her doctor, Dr. Bianco's findings that she would be restricted because of these back injuries and pain as a result of this.
Well, counsel, didn't she return to work almost immediately after this?
No question about that. She works with the pain, but she is affected in her regular daily life by these
And she
problems.
did her normal household activities like cook, clean, things of that nature?
To a reduced extent, she testified. Yes.
Did she hire anybody else to do that on her behalf?
No, she did not. But we're not claiming 9180 here either. And these findings are very similar to the plaintiff in the Torrey versus Avis Court of Appeals case, almost identical, where the Court of Appeals said that these are sufficient qualitative findings to raise a material issue of fact on serious injury.
Okay, so the qualitative findings, we should find them in her deposition where she talks about the limitations that she suffered after this accident and up until that time, 2 years later.
Almost 3 years later, yes, at the time the motion was heard. And yes, that's where those facts are. And they correlate to the doctor's findings in his affidavit that she would experience those limitations qualitatively because of this. So
Counselor,
that's our basis for that.
Counselor, if I could ask a pinpoint question, what does Dr. Bianco say are the qualitative? How does he qualitatively assess plaintiff's injuries?
Much like the plaintiff's.
I understand what the plaintiff says. And
Yes.
where does Dr. Bianco give a qualitative analysis of the significant limitation?
He does in his affirmation where he says that these injuries will impair her ability to walk and stand and engage in any kind of activity. He says that. And it's very similar to what the court found in Torrey, saying that the attending doctor related the assessment to plaintiff's complaint of difficulty sitting, standing, and walking for extended periods. So I refer the court to the Court of Appeals case, which is similar on the facts.
Just to piggyback on Judge Del Conte's question, counsel, I didn't see, and please direct me, I could have missed it, but I didn't see where Dr. Bianco put any numerical value or percentage to the range of loss or the range of use of your client's.
I understand. Yes, Your Honor, and thank you for that question. And he didn't, because this is not the typical case of a spinal injury that causes restricted range of motion. That's what the lower court relied on as well. No findings of restricted range of motion. But as the court in Torrey said, there can be a quantitative finding, such as you're referring to, or a qualitative finding. And as the court found in Torrey, the qualitative finding was enough to raise a question of fact on serious injury. It isn't necessary to have quantitative measurement if you have the qualitative findings, as we do in this case.
Okay, thank you.
As far as the errors of law, and there are several of them, the first error of law is what we just discussed, the failure of the court to accept that the qualitative findings, along with the MRI.
Okay, you've already made that argument.
Okay. The second point is that the defense didn't meet their burden in two respects based on their defense doctor, Dr. Carr. They rely on that, and that he says he can't correlate the findings, injuries, and symptoms to the car accident, but he failed to account for the evidence that plaintiff had no complaints of pain prior to this accident. That's reversible error. This court has held on many occasions that the defendant fails to meet their burden on the issue of causation unless the defense doctor establishes that the alleged injuries were pre-existing. That did not happen here. That's reversible error.
Okay, we'll look at that very carefully.
Thank you. The second matter is that the plaintiff continues to suffer from the MVA-related injuries years after this accident, and Dr. Carr failed to address that as well. And that raises an issue of the fact whether the injuries are permanent. So that's another reversible error. The third reversible error is there's a conflict between the two experts' affidavit, which should not be resolved by the lower court. It presents an issue of fact for the jury to decide. So,
Okay, I think we understand that argument as well.
thank you. That's all I have.
Thank you very much.
Thank you.
684, Shancy versus University of Rochester.
Good morning, may it please the court. I am Amy Koch on behalf of the University of Rochester. This appeal
Before you
arises.
even start,
I'm sorry?
can you please address this issue.
Yes.
It's my understanding that this has already gone to trial. There's a final judgment in favor of the plaintiff in the amount of $57,000 some more. And it was entered on July 12th, 2024.
Yes, Your Honor.
Why are you here?
We have an appeal of that decision, but we had this appeal pending before the,
With this, you don't have this appeal anymore, correct?
well, Your Honor, this appeal was perfected before
I
the,
realize that, but see, do you see the problem that we have? Is that this intermediate order should be dismissed, even though you've appealed the final order, that's the one that should be going up, but this one should not. This one is done.
Your Honor, we did have this perfected. It was on the calendar. We chose to go forward with it. We do have an appeal of the underlying decision as well. We can consolidate the two appeals and return to Your Honors, but this case was perfected and
I
ready.
realize that, but you may have to consolidate the
Okay.
two.
If that's Your Honor's direction, then that is what we will do. We do feel that this is a matter that never should have gotten to a trial. The court made the inappropriate decision on the summary judgment motion.
Thank you.
Thank you.
I was given your statement, I have nothing to add, and I'll rest on what you consider that first.
Thank you.
The jury determination in our favor should end this inquiry.
Thank you.
Thank you. 685, the estate of Carol Ford.
Morning, Your Honor. George Moscato, if I may, please. I represent the appellants with respect to this matter. The primary issue was the initial transfer of title as part of estate planning from the from the wife using this older power of attorney to himself as part of this comprehensive estate plan that he had discussed with his attorney. Involved in the entire process, and it's important to note, was the family. All the children had representatives, and they were involved as part of this transaction. What the lower court
Doesn't
found...
a power of attorney who deeding property to himself or herself, isn't that presumably void?
No, Your Honor, because the power of attorney, as you well know, has a menu attached to it, and all of the categories were initialed, allowing Mr. Ford in this particular case with the Springford power to be able to handle real estate transactions.
Yeah, but deeding it to himself is a violation of trust in that regard. I mean, this is for no consideration as well, another problem we have there.
No, it isn't a violation of trust unless there is some inappropriate behavior. As the court is well aware, a attorney in fact has to act in the best interest of the principal. And in this particular case, that deed was transferred from wife to husband using the power of attorney for, as Mr. Speller had pointed out, for initially Medicaid avoidance, if I could use that word, and as part of this estate plan in which Mr. Ford was concerned about his wife's well-being, the use of the house, to have the proceeds available. So there was an appropriate reason for doing that. He was acting, when he did it, in the best interest of his wife. That's what this was all about. There was nothing of any kind of avoidance here. So there's nothing in the power of attorney that per se prohibits the transfer of the property. If she didn't consent, and then we know in this particular case she was incapable of consenting because of her mental health issues, then I would agree. Yes,
Do you
Justice.
think she would have consented if she knew that as a result of that maneuver and all the others in this record, that one of her children would have been disinherited? I doubt she would have been happy with that.
Yes, Justice Bannister, I would totally agree with you. It was actually 2 children that ended up being disinherited out of the 4. But that came at a later time. However, the point with respect to that deed that went from her to him and then immediately into the family trust, at that point in time, as the court is well aware, all of the children were included in the trust beneficiary provision. So I believe that when you look at the ability of the power of attorney to give the husband the ability to handle real estate transactions.
But wasn't this a gift? I mean, it was for no consideration whatsoever, and weren't the gifts limited to, I think it was $10,000 a year?
Yes, they are limited to $10,000, but it was more than a gift. Even the deed itself recited, and it did use the word gift, but it says for estate purposes, and it was transferred as part of this planning purposes. So what it did was include the other provisions of the power of attorney, real estate transactions.
But
estate
generally those real estate transactions were, bona fide purchases to a third party generally, not a deed from the power of attorney to himself or herself.
Well,
That's, again, presumably void.
Well, with all due
So
respect.
you're getting around the presumably void provision by saying the intent was satisfied.
Well, intent is very important, but also the general obligation law with respect to real estate transactions doesn't say he can't use the deed and transfer it from his wife to himself. It says quick claim, real estate transactions. There's no limiting language in that particular provision of the general obligations law that says, oh no, you can't transfer from a spouse to break up a joint tenancy.
Wouldn't it have been better practice maybe to transfer from himself and as power of attorney to the trust directly rather than this staged process? We wouldn't have this problem then?
Well, he wouldn't have the problem had he not engaged in any estate planning at all. If he had just held on to the house and when they sold it to the third party, he could have signed both parties. But to answer your question directly, I don't know that I have that expertise. I didn't do the estate planning, but it was a plan that was put in place by the attorney, who I thought did a very good job. The entire family was engaged in this process, knew exactly what was taking place. So I think that it happened the way it did, but I don't think it's necessarily inappropriate or less valuable as far as this plan was concerned.
Okay, thank you. I think we have that.
Thank you.
May it please the court, I'm David Seelan on behalf of Christine Ford, who commenced this proceeding below in her representative capacity as executor of the estate of Carol Ford. Now, that is, she's bringing that in her representative capacity, not her individual capacity, and when we say the entire family was involved in the estate plan, well, there was one person who was not involved, and that was Carol Ford. The court below issued a decision which is supportable on several grounds. We've discussed, and you've asked some good questions about the extent to which the power of attorney would authorize the kind of acts performed here on November 12th, 2018. There's a broader consideration of whether those acts were in the best interest, and regardless of where we land on what specifically the power of attorney authorized, those best interest standards still apply. There's no argument below or here that Carol Ford ever directed any of these transfers. It's admitted that she lacked the capacity. She was incapable of consent. And the third grounds, which was held below, is that the tenancy by the entirety is a unique tenancy, terminable only by specific acts, as this court has found for several decades. None of those acts ever happened. And I'm also here on behalf of a cross appeal, which there was no responsive brief. My understanding really is that both parties agree that as goes the November transfer, so goes the result in this case. However, the crux of the cross appeal is that nothing in this undisputed record ever happened which would divest Carol Ford of her rights as a tenant by the entirety. No transfer sufficient to take away her absolute right to the property upon the death of her husband, and by chance, it turns out that she survived her husband. Now, under 2104, Christine Ford was authorized to pursue the remedy of the proceeds of sale and elected to do so. And I think that's proper, given that we have no indication that the innocent purchasers in April of 2019 have any blame or should be divested of a house. But the court below effectively acknowledges by saying we need a new deed. that the deed that's out there isn't good enough.
Yeah, we understand that.
I have nothing else unless Your Honors have any questions.
Thank you very much.
Thank you, Your Honor.
686, Ashley Putnam versus Jason Kibler. Go ahead.
May it please the court, Rob Steinhaus appearing on behalf of Ashley Putnam. I believe that our position is adequately set forth in our brief. It is purely and simply a situation where the plaintiff contends that the court below dealt itself or utilized issue determination when it was not their function, especially on a summary judgment motion. Where this incident occurred, how it occurred, the actions of the parties leading up to and through it are all material issues of fact. Tragically, all three of the people who were there suffer some level of brain injury and death. And I just believe that the trial court should have left that and those determinations to the jury to decide. And it improperly took that from the jury's perspective. Unless there's any questions, I will rest on my papers.
Thank you.
Good morning, Your Honors. May it please the court. Brian Webb on behalf of the respondent, Mr. Kibler. Our position again laid out in the briefs, but this comes down to summary judgment motions and the evidence that the court should consider when they determine these motions. I think it's very clear that while there isn't a lot of evidence in this case, all of the evidence is pretty conclusively clear and undisputed that my client was not in any way negligent in the happening of this snowmobile accident. The only evidence as to the happening of it is that he was driving under the speed limit, he was on a trail, he saw another sled come out, he tried to get out of the way, he couldn't, and there was an accident. That's it. We have the unique situation here also where the appellant actually told my client, I know you did nothing wrong. This is just a clear case of what the evidence is. I respect my opponent's arguments, but I believe that a lot of them are based on conjecture, speculation. Those things are not adequate to raise the question of fact. And the last point I want to bring up, unless the panel has any questions, is that this case was before the Fourth Department not that long ago, about a year ago. And it's cited in my opponent's brief. And while that argument wasn't made at the trial court, I think it's important to point it out here. In that instance, there was an issue of a release and if it should be voided, and ultimately if there was a conflict of interest between someone representing the appellant and my client at the same time. This court concluded in that decision that a reasonable attorney would conclude that there was no conflict of interest for someone to represent the appellant and my client. So without actually saying it out loud, I believe that that decision actually says what we're saying here, that my client was in no way negligent in the happening of the accident. If anyone has any questions, I'm happy to.
Thank you. 688, Stanton versus Chris Reinhardt. Morning. Go ahead.
Good morning. May it please the court, my name is Carmen Nicolau. I represent the defendant appellant Austin Reinhardt in this action. It's submitted that the court below erred when it denied, when it didn't grant my client's motion in its entirety, but denied part of it. And that speaks to the second dog bite that occurred on September 9th, 2021. The issue here and the issue that was before the court below is whether or not my client had any control of the property and or of the dogs. And the facts that were presented to the court were uncontested. Nobody contested what steps my client had taken within that 16-day time period from receiving notice of the dangerous propensities of the dog, which was on August 24th, 2021, and when the dog bite occurred.
Counsel, let me interrupt you. I think from this record, we could see that it's unmistakable that your client didn't do enough, okay? Because the dog stayed there for another 16 days and was in a position and eventually did attack somebody else.
The issue of whether or not my client didn't.
Same person.
Oh, same person, yes.
Yes, it did. It attacked the same person. The issue here is there's two parallel situations going on. My client learns of the dog attack on August 24th, 2021. He calls his lawyer's like, you can't do anything, we can't evict him, there's a moratorium. He tries to take over the dogs, he couldn't take over the dogs. Yes, there's a lease, but the lease in of itself requires a 30-day notice before an eviction could be placed. And again, there was a moratorium at the time. And then
How did your client try to take over the dog? Did you just say, hey, brother, I'll take it, and he
he
denied?
went up to the property. Well, the dogs are property, and these courts have recognized that dogs are property, right? So he went up to defendant Reinhardt, and he said, let me take the dogs from the property. I will take them with me. I will take them off the property. I will bring them to my and he refused to relinquish the dogs. Now, here's the thing, though, but at the same time.
Well, what do you do? What do you do subsequent to that? Anything, as far as watching over, making sure the dog was restrained somehow, by going back to the property and looking at it? I mean, what else you did?
You have a situation where the property is leased to defendant Reinhardt.
I understand, but that's his property.
Pushback about being on the property, and you gotta remember.
Couldn't he have gone, he thought that they were building a fence, couldn't he have gone back and built a secure fence and made sure that the dogs couldn't get out? Weren't there things that he could have affirmatively done?
At the time that he went to the property, the fence was being erected by defendant Reinhardt and his friend. Not to mention, there's a town of Granby court order that directed the dogs stay contained within the home, which is critical. The home itself had a front door that locks, had a back door that locks and closes, and that the only reason these dogs escaped or got off the property and attacked the plaintiff is because the front door was intentionally left open by defendant Reinhardt, not because of any malfunction. He violated a court order when he allowed the doors to stay open and allowed the dog to remain on the deck, and then he basically jumped over the gate and then ran to the property. So you have a parallel situation where my client is doing what he can do under the circumstances that he was given in that 16-day time period. And then you have parallel to that, the town of Granby going, well, listen, you need to keep those dogs contained behind closed doors. And the only reason this attack occurred was because the defendant Reinhardt left the front door open, the dogs escaped and went to the other property to.
So arguably there's an issue of fact on whether or not your client controlled this property or not.
No,
After he acknowledged that this dog significantly injured the plaintiff in the initial attack. He was well aware of it, and it happened again. So under his arguable control.
Obviously, you're not going to agree.
What control? I'm just the
That's an issue of fact. I mean, we've laid out a couple of things that could have been done. I mean, it can be laid out at trial as well for the jury to make a determination of whether or not there was adequate control.
I respectfully disagree. I'll rest on my brief. Thank you.
That's okay.
Thank you.
That's not a problem.
Good morning, Your Honors. May it please the Court, my name is Craig Nichols, and I represent the plaintiff respondent, Dwayne Stanton, in the instant case.
I assume you're going to say there are issues of fact here, and that's dispositive.
Yes, Your Honor. I'm aware that the Court is fully aware of my brief as I submitted it and the facts contained therein in the law. I'll